Just a few words before I get into the main argument that we're trying to make on this paper about the way we came into the question of mercenaries and mercenarism, and the way the discourse on mercenaries and mercenarism enabled and legitimized the use of force in Libya in 2011. And I need to start by saying that the person who actually knows stuff about mercenaries and mercenarism is Catherine. So all your general questions that assume doctrinal knowledge, please direct them to her. The way I got into the issue, and it has somehow survived still in the footnotes, and I think in the general preoccupation of the paper, is the way in 2011 both international and domestic discourses, both legal and political, really juxtaposed Libya to Iraq, right? So the idea was that Libya was almost the salvation of international law and the salvation of using force across borders, because it was happening legally, it was happening pursuant to a UN Security Council authorization, and therefore it was in a sense exorcising the specter of Iraq and the specter of the perceived lawlessness of the Bush administration. And even though the moment is like almost 10 years ago, we do think that there is something important about it, because of a very similar anxiety today, obviously about the position of the current US administration towards all things international, and to the extent in which this anxiety can lead to a certain romanticization, obviously, of international law, as it was happening. And I think that's a very interesting thing, and it was happening just 10 years ago during the Bush administration, right? We all had to rally back and save the international, rally behind the international legal order and save it from this lawless administration. And here came Libya as this perceived salvation moment. So for those who perhaps don't remember it, either due to their age or because they really have tried to forgotten it, this was, especially for liberal internationalists, a moment of euphoria. The idea was that resolutions 1970 and 1973 had brought about a new, much more humanized international legal order that, as Tendai and Nasli were saying before, used force in order, and especially really destructive force, in order to protect human rights. And obviously, subsequently, due to the collapse of the state apparatus in Libya, a certain ambivalence ensued about these experiments, and especially there has been a debate, relatively extensive doctrinal legal debate, about whether the actual acts of NATO, and especially the fact that NATO actively participated in overturning Gaddafi's government, was inconsistent with the UN Security Council authorization. And these debates are very long, and they're in the footnotes and everything, but we are worried that the problem ran much deeper, and that the problems had started long before NATO going after Gaddafi, for a number of reasons. And our main reason here is the existence, both in the popular and, as we will show, in the legal discourse, of a particular narrative, which was Gaddafi's regime. One of the reasons that make the Gaddafi government so abhorrent and really necessitated it being overturned was that he was standing against his own people by recruiting African mercenaries, and Africa here meant very, very clearly black mercenaries. And also there were again all these narratives going on, and Hillary Clinton would talk about them also, about how these mercenaries were particularly brutal, allegedly, and also how they were the source of widespread and organized sexual violence against Libyan women who were opposing and protesting against Gaddafi's government. And what we want to show in this paper is the very different treatment afforded to these mercenaries real or imaginary, as I'm going to say in a moment, the very legal treatment afforded to them in comparison to the general unwillingness of Western nations in general and of the Security Council in particular to tightly regulate the use of mercenaries in other contexts, especially in contexts of conflicts in Africa. And we're arguing that in this case, race, proximity to Western interests, and incorporation or not to corporate structures of security provisions have been determinative of the legal treatment of foreign fighters, of paid foreign fighters in international law. Or in other words, through resolutions 1970 and 1973, international law, and especially the Security Council, intervened and pronounced about what sort of bodies, to adopt Tendai's language, can cross borders in order to fight as a job. What sort of bodies can do that legally and lawfully, and what sort of bodies actually constitute a threat to international peace and security when they cross borders and they get involved in fights for pay, or if they're perceived to be doing so. So the story of Libya, the legal story of Libya is, of course, that in Resolution 1970, the Security Council did not authorize the use of force, but it clearly adopted the language of the responsibility to protect. And also what it did, and I think is really important, if you look back in the annex of both Resolution 1970 and 1973, which is always where the fun is in Security Council resolutions, it imposed targeted sanctions against a number of individuals, including a Libyan ambassador in sub-Saharan nations, in Chad, in Niger, in Mali, and so on and so forth. And we argue that this was actually the way in which the Security Council subscribed to this idea of the foreign mercenaries, and actually the way in which, not explicitly obviously, but it also singled out a particular group of foreign fighters, the foreign fighters from sub-Saharan countries, black foreign fighters, as particularly dangerous for the situation in Libya. And the second way in which we argue the Security Council again ratified this narrative about black danger in Libya was again by singling out a category that up until the point was pretty unknown to international law, the armed mercenary personnel, as a particular threat to peace and security. So the idea was that it was not all foreign fighters that were dangerous, it was particularly the armed mercenary personnel, which is, for those of you that are familiar with international humanitarian law, it's a somewhat peculiar formulation, and it's unclear whether it coincides perfectly or not with the idea of mercenary in Additional Protocol 1, which is an extremely, extremely narrow idea of who is a mercenary. Basically, you have to be pretty stupid to end up falling under this category. It has been tailored for people to be able to navigate and escape it for reasons that Catherine is going to explain. And the third reason we think that the Security Council intervened and ratified and assigned legal consequences to the idea of black mercenaries raping Libyan women was the very central role it designated to the Arab League in juxtaposition to African forms of regionalism as relevant to the context. So the idea was that the most relevant regionalism in that context was, of course, the Arab League. And this needs to be read, we argue, as part of a general anxiety about the reorientation of Gaddafi's government towards a more African idea of what what is the relevant regionalist there, and as Gaddafi positioning himself basically as some sort of leader, anti-imperialist leader in Africa. And the reason that these narratives about black mercenaries became so easy to believe for a number of reasons, obviously including racism, was an ongoing international and domestic anxiety about this realignment of Libyan reimagination of Libya as an African state. And I'm going to stop now and give the floor to Catherine to explain how particular and exceptional this treatment of mercenaries is in comparison to the rest of the international legal regime.
Okay, thank you. Thanks to the UCLA Law Review for having us, and inviting me, and to Asla and Tendai also for their efforts here. From my perspective, I always struggling with how to bring my own work into the context of the more explicitly the racial discussion, the legacy of CRT, and more to the point, TWAIL, in terms of the work that I've done, focusing on mostly criminal prosecutions of individuals this government has deemed to be terrorists or charged with terrorist-related crimes. And I think, when I started to look just by chance at the UN terrorist or counterterrorist system, the word counterterrorism is an awful word. That's why, of course, I chose to name my seminar Counterterrorism, but that's another story for another day. But anyway, dispensing with my objections to any nomenclature, I think when I took a look at the UN system, the UN counterterrorism apparatus as it exists, I was stunned by how it had uncritically adopted so many of the American formulations. And the more I looked, the more I found to be kind of problematic. And I think the approach I took is more kind of granular. And so maybe in the final formulation of the paper, when I get around to kind of fixing it up after this first draft, I'll try to make those linkages between the greater theories and TWAIL and critical race theory. But for now, the focus is a little more detail-oriented, granular, so to speak. And because when we look at the international system and what it refers to as counterterrorism, we can figure out who the sort of terrorist is, what that person's particular identity and makeup is, what form terrorism takes. And the structure as it exists, given to us by the powerful actors in the international system, takes quite a toll on human rights. Specifically here, the prototypical terrorist, as we've come to understand, mostly him, but sometimes her, is a non-state actor of an Islamist bent, okay? And when we look at the UN documents on terrorism, we see that this construct with its implicit biases is reflected in those materials. The terms and concepts that have been employed by the UN, radicalization, preventing and countering violent extremism, and the phenomena that the UN system identifies, the scourge of foreign fighters, etc., all suggest what the fine print makes explicit. Terrorism is Islamism for the most part. To the extent that terrorist groups are named explicitly, that is to say, the only ones identified are the Islamic State and the formulation known as Al-Qaeda, which, by the way, may be a complete, we've been laboring under this for 20 years. It may be a complete misnomer. There's a historian at UC Davis who basically, Al-Qaeda means the base in Arabic, and he went to Yemen and he found that basically that there was a bunch of preachers who kept making use, Islamist preachers who kept referring to the base as in the military base of a particular organization. So it never meant to name itself Al-Qaeda, but that's another story for another day. Sorry, I almost hit Chris there in the face. That people here are not that safe up on the panel. Once I get a full head of steam. Okay, so proceeding on a dual track, the UN has two major counterterrorism entities. I'll dispense a little bit with the discussion of the Security Council the Security Council body, because I think we all are aware of the deep problems with the Security Council and how it operates and the 5 permanent members who can veto anything. But essentially the focus here of the major international body when it comes to terrorism is that it's non-state violence of a political nature. So obviously, maybe it's an inevitability that an organization made up exclusively of nation states or those aspirant nation states, that the complex and contested phenomenon of terrorism is going to be confined to the acts of non-state actors. The question of state terrorism is left unaddressed. It's just plainly not on the agenda. That has obviously a long history in the UN, and it's kind of culminated in this moment where we don't even deal with state terrorism, we just deal with non-state terrorism. Again, there's a Security Council body, but that's less important. I want to focus more on what has become to be called the United Nations. That was a misnomer. That was a slip of the tongue, but United Nations Office of Counterterrorism, which was passed by a UN or created by a UN General Assembly resolution in June of 2017. It's now headed by someone who has the title of Undersecretary General, which is this is, quote, the first major institutional reform undertaken by the Secretary General of the UN. Now, once you get beyond the mildly impenetrable, as I put it, globalized jargon about the goals of the office, that is to say, strengthen the delivery of United Nations counterterrorism capacity building assistance to member states, end quote. It seems that the office is geared to adopting a uniform plan, which has come to be called the UN Global Counterterrorism Strategy, across the institution of the United Nations, and have that strategy instituted into the domestic policies of the member states. The 4 pillars of the strategy are kind of boilerplate. Strengthening capacity, the usual global jargon. The last one does give a nod to making sure that any counterterrorism policies comport with human rights, but that's a mildly quixotic exercise. Again, coming back to this issue of what constitutes the terrorist threat that has to be countered, basically, this whole enterprise suffers from the lack of an internationally agreed upon definition of terrorism itself. Even though there's a kind of a general understanding you can't kill civilians in peacetime for political ends, that's not really the lack of a definition. And again, I'm hardly the first person to make this point, but it still kind of runs through this whole effort. Now, basically, to buttress my point about the terrorists being Islamist in the main, let's look at June 2018 in New York. There was a, quote, high-level conference of heads of counterterrorism agencies of member states that the UN Counterterrorism Office held. There were 4 sessions, 2 of which focused on fighting terrorism by combating the threat of violent extremism, and also that of foreign fighters. And this is not explicitly racist, at least if you look at it at face value, or take it at face value, but what does it mean? Countering violent extremism, which actually that phraseology comes from this country, which essentially is concerned with violent extremism of an Islamist bent. So violent extremism really means Islamism. Again, you have to kind of read through the lines. And it's an offshoot of the theory that individuals can be radicalized, which again targets Muslims as the threat under the cover of racially neutral language. The other of foreign fighters, we don't need to say more, foreign fighters is specifically associated with the so-called Islamic State threat. And this June 2018 conference has spawned a series of regional high-level conferences, all building up to the second United Nations high-level conference of heads of counterterrorism agencies of member states, which is scheduled for June 2020 at the United Nations in New York. Now, where are these conferences taking place? In places like the United Arab Emirates, Hungary, Belarus, these are not countries that I would call bastions of human rights protections or boast strong civil society institutions. But they do remain focused on counterterrorism and all that that can produce in terms of a lack of cohesive focus. So, for example, they start, if you read some of these documents, all of a sudden they'll bring up the link between terrorism and illegal drug trafficking. Okay, they don't seem to produce any evidence about, you know, where this link comes from, how it is that drug dealers and terrorists are working together. Okay, I mean, I'm not saying it couldn't exist or it doesn't exist, but the evidence has not been produced. All I can look back is on my own kind of investigation of American narco-terrorism prosecutions, and where there's a statute in this country that outlaws, you know, and provides enhanced penalties for people engaged in drug dealing activities that supposedly further terrorism. The most famous of those prosecutions was when the FBI sent an informant to Mali and basically went around asking people if they would, you know, find a way to get drugs, his drugs to Europe, and on behalf of Al Qaeda. Of course, people in Mali, a relatively poor state, said, "Sure, we want your money." Then the next thing they know, they're being flown to New York to be prosecuted. So I don't know that again, I can just go by what the record is. I can't, I can't make up more. I'm unconvinced about that link, although these UN conferences presuppose it, and member states take up this kind of mantle that terrorism and organized crime and drug dealing are working together without giving much evidence. Okay. The UN, by the way, the UN Office of Counterterrorism, I should say, it's not like the US national security apparatus in one sense, in that here the national security agencies, lowercase a, plural, have seemingly limitless budget, whereas the UN is actually shilling for money and has produced a slick brochure which features, if you want to know who the terrorist is, lots of people from Asia and Africa dressed in native, mostly Muslim garb as a ploy to get money. So it's a little bit different. And also all these efforts are located in countries with Muslim majorities or have a significant Muslim population. They're all located in Asia and Africa. The single European country that has UN counterterrorism activities is Kosovo, which is it a country? Well, okay, I won't pick that up. And again, who gives money to these operations? It's mostly Saudi Arabia and Qatar. Saudi Arabia giving $110 million and Qatar giving $75 million. Now ask what those countries have done to further terrorism in Syria, Yemen, etc. We won't ask those questions, but we'll just raise the issue. Okay, as a final point, because time is up. Okay, as a final point, this regime has produced, this counterterrorism regime has also been problematic for human rights and civil society in many countries across the world. There is a UN special rapporteur for protecting human rights in the counterterrorism regime, and she's documented many cases of repression of speech, political protest, etc. And what we've also seen here in this country and in Britain as well as in Europe is the new phenomenon of stripping citizens of their nationality, mostly under the cover of the foreign fighters associated with the Islamic State, but actually it started well before that. I think the upshot of all of this, is that we have a counterterrorism regime. That essentially has adopted the American sort of counter-terrorist logic. For the most part, other large nations are quite happy with it. China, Russia, etc. And also smaller nations are happy in the sense that they get to use this logic against their own citizens and cracking down on civil society. To make a final point here, I don't think we can discount or downplay the racial, ethno-religious link here. So many of you might remember in the wake of the Christchurch shooting of March, the Christchurch mosque shooting of March 2019, the Prime Minister of New Zealand, Jacinda Ardern, said, we should never name the fellow who did this, okay, because we want to deny him notoriety for his actions. If it had been a person with an Arab or Muslim or related name, that would have never pertained. He would have been named right away as to show who the nature of the threat is. So even though she took a very courageous position, I think that the UN counterterrorism project makes clear who the terrorist is and all the relevant problems attendant to that. Okay, thank you.
Thank you very much. John?
Okay, thanks, Chris. And just to reiterate the thanks to all the amazing organisers and also to the amazing Asle Tendai double act. Thank you for having us all here. For me personally, at this time of year, to get out of Ireland and come somewhere where there's a blue sky and actual sunshine is a lovely treat. So thank you also for that. And just really happy to be here and to get to keep learning from all the amazing work that's been done. So my paper is trying to think about the relationships between emergency and migration and race and the nation. So that's the kind of rhyming couplet title that I have. So I'll try and talk firstly about emergency and the nation and about how international law has understood or defined those concepts, and then try to think about what that can tell us about migration and race in the European border context. So I am conscious there's a full panel on migration in the afternoon with people who know way more about this than me and have been doing amazing work on migration and race and on the inability of international law to fully reckon with that. And I've learned a lot from the work of some of those people, Jaya and Chantal and Tendai and many others. I referenced some of it in the paper, but I will just also apologise in advance if what I'm saying sounds somewhat superficial on that front. I was also just thinking when Ashley was talking earlier about connecting the work on counterterrorism and national security with questions around migration and borders. And so in a way, I think that's what I'm trying to do with this paper. These ideas obviously are deeply entangled, and one useful way I think to think about the connections between them is through the notion of emergency, crisis, and the work that does. So the little kind of intro vignette I have in the paper starts with this moment last September when the new president of the European Commission announced her team of commissioners, and in that context, what was previously called the Commissioner for Migration, Home Affairs and Citizenship gets renamed as the Commissioner for Protecting Our European Way of Life. And so our European way of life in this context, I think, is, among other things, code for whiteness. And so, and in the context of this announcement, she refers and kind of invokes the usual tropes around legitimate fears, and she says we have to address legitimate fears and concerns about the impact of irregular migration on our society. And again, going to the discussion earlier and some of Darryl's comments that you referred to, and this is a kind of a superficial example about the politics of representation, but I think we see very clearly the way in which European does remain a euphemism for whiteness, so the Commission President starts boasting about her team of commissioners being as diverse as Europe is. And so there's 27 commissioners, there's almost 50-50 gender balance, they're from all the different countries around Europe and various political groupings and so on, but obviously all 27 of them are white. And so we see that, I think that, the idea of Europeanness as whiteness coming through there, and the clear implication in this process, I think, of making migration control at this particular historical moment in Europe about casting that as being about protecting a European way of life. The implication being that the preserving this idea of Europeanness as whiteness does obviously require heavy restrictions on migration from non-white spaces. And so in that move, far-right ideas about migration, I think, are essentially now incorporated into mainstream politics in Europe through the lens and the language of racial non-discrimination and colourblindness on the face of it, operating as a veneer really that allows for centrist and liberal positions on migration to remain righteous in their own perspectives, while effectively incorporating and mimicking the far right thinking on these issues. And so liberals will balk at the overt racism of the far right, but are for the most part really at peace with the core premise of nationality-based migration rules, which in practice, are very clearly designed, and we see this in the European immigration system and the visa rules and so on, very clearly designed and set up in a way that's indirectly but very predominantly race-based in how it operates. And so, and that's the system that international law creates and facilitates. It's a starting point for arguments by scholars like Tom Ferrer is one I mentioned in the piece, who make the case for what he calls liberalism with borders, and argues that there is no contradiction between supporting liberal values and human rights on the one hand and opposing migration rights for communities racialized as illiberal on the other hand. And so that's the liberal position in a state of normality. And so my argument then is that that's the starting point, and then in the notion of migration emergency or crisis provides scope for regimes like the European Union to further harden and entrench its border regime at opportune moments, and that international law and its understanding of emergency is implicated in this. And so I have a section about emergency as racial sovereignty, which goes through some of this in theoretical terms and finishes with the point that so I say, in thinking through this relationship between borders and legal political framings of emergency, my contention is that liberal legalistic constructs of first world migration crises, of human mobility for some as national emergency for others, this idea of protecting our European way of life as a kind of a technocratic euphemism for Fortress Europe, that all of this amounts to some form of coded incorporation of these far-right ideas of the Great Replacement or of white genocide. And this centres around racialized understandings of the nation, imaginaries of the European nations as white nations, and in this configuration, the migration of too many people from non-white communities is seen as posing not only integration or security or resource challenges, but is an existential threat to the life of the European nation itself. And so the concept of emergency and the state of emergency, okay, so I've 7 minutes gone, I've 5 minutes left, is that right? Yeah, okay. Right, okay, so the concept of emergency, it appears in various different subfields of international law. Human rights law is one where I think we have some of the most interesting drafting records and jurisprudence on what is meant by an idea of state of emergency. I go through some of that drafting records stuff and how the emergency is defined in the European Convention of Human Rights, the Covenant on Civil and Political Rights, and how it's driven very much by the British position and the British context of being in and using emergency powers throughout the empires, throughout the colonies in the empire at that time, and insists on this idea and necessity of having the possibility of suspending human rights obligations in an emergency. And one other interesting development which I point to in how an emergency is defined in those processes and what happens very late in the day in the finalization of the texts of those treaties is that the definition of the state of emergency gets changed from an emergency threatening the interests of the people to an emergency threatening the life of the nation. And so we have this idea of the nation brought in, which seems to show a preference for this norm and this definition of emergency being rooted in a more fixed and arguably ethno-racial concept of the nation, rather than what it was previously in terms of a more potentially more fluid and expansive and potentially more inclusive notion of the people and their interests. And so under this definition, and we see this playing out then in how it's invoked and utilised by Britain, among other states, in a way that reveals racial contours over time. And so I won't have time to go into all the examples now, but from the state of emergency in Kenya in the 1950s, which was legalised under British law and international law, the nation and the life of the nation said to be under threat there was not any particular or collective Kenyan nation, but the white settler nation and the British nation by association. And so the brutality and the internment camps and the forced labour and all of that is legalised and justified, even though it's done in a very openly racist manner. The state of emergency operates to insulate that. Similar iterations of this in Cyprus, in Northern Ireland, in the War on Terror, all of which get brought up in the European Court of Human Rights and get challenged. And the bottom line is that the European Court essentially comes up with an interpretation of emergency based on the definition that privileges the British imperial position, and that also privileges a particular idea of Britishness in the war on terror context, particularly which is contrasted to Muslimness as other than white, where you have the existence of a suspect community, even where it includes citizens of the state itself. It's cast as a threat to the life of the white majority nation. And so we have Stuart Hall's comments that the Britishness has always been racialized through and through, and it's always been equated with whiteness, and we end up with an understanding of the nation in this context rooted in an international legal concept of sovereignty and its right to exclude. And so here we see international law understandings of the nation as increasingly useful to the political project of white nationalism, and that plays out then in the migration scenario, which I don't think I'm going to have time to fully go into, but I try and trace this. It goes back to the 1990s and some of the early agreements and deals that Italy signed with Libya to outsource its border controls. You have Gaddafi at certain times baiting European Union leaders, saying, I need 5 billion to stop illegal immigration. If you don't give me that 5 billion, Europe will become black, he said. It will become overcome by people with different religions, and it will change. And so that's the background. And then we have, from 2011 onwards, particularly 2015 context, this sense of a migration crisis or an emergency in Europe emerging, and not just the far right seizing that opportunity to escalate its rhetoric, but the European Union in a centralised manner, declaring these emergency summits, implementing emergency measures to be able to identify and deport people quickly that are identified as, or can be identified as economic migrants, as well as individual member states declaring states of emergency on the perimeters of the EU, particularly to allow armed forces to be used to reinforce the borders and so on. And so, I know there's despair in the front row here, so I will stop talking now. And I know there is another panel coming afterwards at a specific time. I will just note that my clock still now says 12 minutes gone, but ultimately my contention is that international law is very much part of the story of how this emergency is created and defined and wielded with racializing effects, and that, as it stands, international law is also not equipped to counter this process. And I think that will be addressed as well more fully in the next panel. So maybe that's a good place for me to stop. So thank you.
So that was wonderful, and it's my job to try to bring together the papers. And I thought one way of thinking how they relate to one another is that they're all concerned with questions of who can move and who can use violence. And for the most part, they're about constraining or enabling the movement and the use of violence by white bodies and constraining the movement and the use of violence by black bodies, either as terrorists or as mercenaries. And one way to come at that relationship between them, so movement and violence, is to think of the racial contract as always being underpinned by violence. Right? Whiteness is necessarily contingent on violence, the same way law necessarily is contingent on violence, because the racial contract to be global has to be enforced at every moment, at every particular turn, through violence. And so it's authorized, white violence is authorized by the very idea of whiteness to enforce that contract. And necessarily, because race has to then be universal, white violence has to be universal. It has to be necessarily always possible in the colonies and also in the metropole. And if you think of it in those terms, always global, always international, always a relationship between movement and violence, then the state as the site of violence is kind of the way Ngugi says that the state or the colonial state is an interlude between corporate rule before colonialism and corporate rule after colonialism. White violence is kind of the same. The state takes on the role of violence, but before that you have violence at the hand of privatized slavery and colonization, and afterwards you have it at the hand of white mercenaries. So there's something about the relationship between movement and violence that I think can be productive. True to form, I want to just make one sort of intervention on each paper relating to history and one novel. I've allowed one novel per intervention, and then shorter interventions about each other one. So something that struck me about all of the papers is that there's a longer history to all the conversations going on, right? So if you think about the World War I, so the conversations between the imperial powers in World War I were much about how dare you arm black men to fight against white men, right? So if you follow the twos and fro's between the Germans and the Allies in the blue books, and they're accusing each other of various crimes. One of the allegations made by one side is that the supreme crime of the First World War was the arming of black men in order to use violence against white men. And this was one of Smut's main concerns. Smut's main concerns was to colonize in order to pull back the guns from the hands of black men in Africa who had been given them by the Germans. So there's a longer history of that 100 years ago, of this fear about racialized violence. And there's also a longer history in terms of borders, right? So even where we stand today, I was struck when you, John, said whiteness and Britishness are the same thing. I made the mistake yesterday going to Santa Monica to go to a bar, and I saw a bar called the British Bar. And the British Bar has about 8 flags, and it's England, Ireland, Scotland, Wales, Australia, and California. Right? And that's an interesting idea of what it is to be British. It wasn't a Commonwealth. Obviously, British in that context means something. But there's a history of anti-immigration laws in California, right? And the prevention of immigration from changing the character of the white nation of America at the time. And Woodrow Wilson is part of this, obviously, in interesting ways. And then this is a bit of a stretch, but one of my novel references to a guy called John Buchan, who is said to be the bard of whiteness by Bill Schwartz. So international lawyers like to think of themselves as being somewhere between Conrad and Kipling, but really it's Buchan and sort of trashy fiction that are the closest to the imagination of white international lawyers. And so Buchan writes a book in 1916 or 17, I think, called Greenmantle, when he imagines this global conspiracy by the Ottoman Empire to take over the world. And then, obviously, the real threat is not the Germans, it's actually the whole time we've been fighting the Germans, the Ottomans have been organizing, and that's what's coming next. And what's interesting about that novel is it tracks quite closely Boris Johnson's novel that's written 100 years later about the threat that's coming from the Ottomans, or threat that's coming from the south. And so I thought, if it's true that there's a longer conversation, or there are previous historical episodes of movement of racialized and sexualized bodies, of immigration, then how does race change between them? So what is the conceptualization of race that happens 100 years ago, and what does it happen now? Because what I saw, certainly in John's, and to some extent in Dina's and Catherine's, was a very biological understanding of race, right? So the reason why you had to protect white nations 100 years ago was not just to protect white nations, it was because whiteness itself would be bred out, essentially. This was the fear of the rising tide of color. The idea was that whiteness as an ethnicity would eventually, because of the intermixing of so-called white people and so-called non-white people, and because of the hypersexualized nature, the race black over-sexualization, that was inevitable. So this is what Stoddard is talking about and what Spencer gets obsessed with eugenics about. So it wasn't just about protecting particular countries as white nations, it was whiteness itself that was then through borders maintained, right? So and when you talk about the European way of life, I'm thinking life as a biological reference, not just life as in terms of customs and culture and manners, but life in terms of the very essence of what it is to be a thing as finances, a thing that is biologically organized. And so that really ties in that over-sexualization is the same kind of understanding of they're not just mercenaries, they're not just armed black men, they're armed black men who are hypersexualized, right? And that's precisely the kind of language that liberally we had left behind, with more complex ways of understanding race without racism and more complex ways of talking about terrorism but not really talking about terrorism. And there seems to be something like a reversion to those crass biological, ontological, racist discourses, even in polite Europe and at polite bars in Santa Monica, that I think is worthwhile thinking through. What is it? How is that different? And only because Michael was I'm emulating everything you did. So you said there's a text you should read. So Frank Ferreri's written about this, called The Silent War, about the evolution of concepts of racism in the white imagination. That was always in response to the fear of a rising color consciousness from the black world. And so that's what he calls a new racial etiquette emerges in the 60s and 70s in relation to trying to move away from biological discourse because it becomes a bit unpopular. So I guess I was thinking about how much you map on those different conceptions of race. And then just a quick intervention for each of you. So John, the Lauterpacht story, the story of the UDHR and the evolution of the security provisions and that. So Lauterpacht, in his initial 1945 International Bill of Rights of Man, has a disclaimer to the section on political rights, and he says that this does not apply to black South Africans and to black Americans. And the reason it doesn't apply to black South Africans is because to give black South Africans a right to vote, he imagines in 1945, would essentially be suicide. It would have changed the character of South Africa as a white republic. So as a precursor, maybe expanding the analysis of how nation becomes associated with race in the UDHR, you can go back also to political rights. And he does this explicitly, and it's not really discussed as to how Lemkin, the father of, so Smuts gets a lot of heat, but Lemkin Lauterbach has some problems as well, and as does Lemkin, in fact, have some problems in terms of his understanding of race. And then I'll group you guys together because I'm conscious of time. The idea of definition, right? So when you're talking about definition, the problems of definition, we have these categories that are so obviously overburdened by racialization, but we can't get the legal language right. So I was thinking about mercenaries and definitions of mercenaries. I was thinking about terrorism and the impossibility of defining terrorism. Organized crime, so I, for my sins, teach a course on criminology, which is way outside of my field of expertise, but it gets me off teaching on the weekdays. And one of the things about organized crime is that also it's a definition that cannot hold together without some type of racialization, right? Organized crime doesn't really work when you try to find it unless you have in the back of your mind a particular Eastern European community initially was sort of Italians and Sicilians. So this inability to define things unless race is backgrounded, I think, comes in both of those two papers. And to some extent, the idea of the drug trafficking and sort of rhetoric around drugs and people coming from South America bringing drugs. So there's something about those, and I wanted to finish in terms of bringing together the question of law and race. So there's a similar problem in defining whiteness. So one of the things I start with when I teach first-year law is the way that the apartheid state tried to define what a white person was. And this is, if you want to think of difficult definitions. So a white person is, quote, in appearance an obviously white person who is generally not accepted as a colored person, or is generally accepted as a white person and is not in appearance obviously not a white person. And I thought of terrorism, and I thought of mercenarism, and I thought of organized crime. Thank you.
In the American legal context, it's called "I know it when I see it."
Yep.
You know?
Yep.
So yeah.
Please join me in thanking the panel.